Let me get this lawsuit pulled up because we're going to go over the civil case that Jeffrey Feiger filed in the case of the Crumleys against the school, the Oxford Community Schools. So here, let's turn on. We've got a slideshow of photographs from different parts of this case. You get to see that instead of me right now. There's Jeff Feiger. Everybody knows Jeff Feiger. All right, so here we have Jeffrey Franz and Brandy Franz. And they are the parents of the two kids. Me either, Scott. Me either. They are the parents of two of the kids who were affected by this shooting. I think one of the kids was shot. The other one is the sister and is traumatized. So that's where this comes from. This is not from a deceased family. This is someone who was injured. And this one, alrighty. So now come plaintiffs Jeffrey Franz and Brandy Franz as next friends of Riley and Bella, a minor, by and through their attorneys, Feiger, Kenny, and Harrington PC. Now you guys all know Feiger was Dr. Kevorkian's lawyer. You guys remember Dr. Jack Kevorkian? I know I've got a lot of Michiganders in here. I know y'all know who Jack Kevorkian is. But not everybody does. Put a 1 in chat if you know who Jack Kevorkian is. Put a 2 if you're like, who? So on November 30th of 2021, now mind you, this was filed on December 9th. A week and a half after this happened, right? So on November 30th of 2021, I'm waiting to see those 2s. Horrific events took place at Oxford High School, which resulted in the slaughter of 4 high school students and serious gunshot and psychological injuries to others. The horror of November 30th of 21 was entirely preventable. Now you're going to have to tell me as we go through this, do you believe, with the wording of this, do you believe, what this lawsuit claims as far as the school goes? And for those several 2s, Dr. Kevorkian was a doctor who was doing medically assisted suicides in Michigan. And he was ultimately sentenced to, I think, life in prison. He got sick. And I can't remember I think he died in prison or they let him out and he died right when he got out. So he got a little crazy at the end there with organs and shit like that. But his initial cause was to help people who were ill commit medically assisted suicides. And Jeffrey Feiger, the lawyer that filed this lawsuit, was his lawyer. So it says the individually named defendants are each responsible through their actions for making the victims less safe. Oh, he did. He quit eating. That's right. The Oxford High School students and plaintiffs in particular would have been safer if the individual defendants had not taken the actions that they did. Now we're going to get into the actions of the school officials. The Oxford Community School District is responsible for having a constitutionally deficient policy, custom, and practice that was a driving force behind the constitutional violations. Further, the school district ratified the unconstitutional actions of the individually named defendants. A lot of this is mumbo jumbo. I will skip over. This is where it gets number 5. The amount in controversy exceeds $100 million, excluding interest, costs, and attorney fees. So at all times relevant here too, plaintiff's minor Riley was a resident of City of Leonard. They all lived in the City of Leonard, County of Oakland, State of Michigan. Riley and Bella were students at Oxford in 12th and 9th grade. Riley was an honor roll student preparing to enter college, and Bella was a star athlete getting ready for driver's training. So that's what these kids were doing prior to November 30th when Ethan decided to take the gun that his parents gifted him for Christmas to school. Getting ready for college and getting ready for driver's training. So now we go on to the Oxford School, and it says, upon information and belief at all times relevant hereto, defendant Timothy Throne, hereinafter referred to as Throne, is a citizen of the state of Michigan and was acting under the color of the state law within the course and scope of his employment as superintendent of Oxford Community Schools. So the superintendent just came out the other day as well, which I'm going to show you a clip of him talking about the breach that just happened last week. And he's clueless. He's like, I don't know how we can fix this. I was like, what? What are you talking about? Why are kids still getting their backpacks in to the school? Someone went into the school, completely walked in. No one's looking, no one's watching, no one's monitoring shit. And someone gets in and there's a breach, and the superintendent's like, well, I don't know how we got to figure out how to prevent this in the future.
What?
Okay, so I mean, you wonder sometimes where these school officials get their common sense. You have to wonder. I wondered this several times when my kids were in school. Not every person, but some of the people that I had to deal with in the school districts were so lazy. Didn't want to do their job. And they would be mad when you held them accountable for not doing their job. It's a mess. Okay. So Timothy Throne is the superintendent. Stephen Wolf is named in this. He is the principal. Ryan Moore is the dean of students for Oxford High School. And then Counselor 1 and Counselor 2 are not named. And then we have a staff member who isn't named, but they are just listed as a staff member at Oxford. And then there's teacher number 1 and teacher number 2. Now, those teachers are the ones that saw Ethan drawing and Googling ammunition. But I do believe, yes, they can search your bag at school if they have a reason. But this school didn't involve the resource officer. They never told him. We're going to find out more about that. So here we go. Riley is 17. Bella is 14. Ethan Crumbley was a 15-year-old male sophomore. And on November 30th, Ethan Crumbley brought a Sig Sauer 9mm semi-automatic handgun to Oxford High School and opened fire, slaughtering students, resulting in the death of 4 and seriously injuring 6 other students and a teacher. So he injured 6 and killed 4. Upon information and belief, in the days leading up to the November 30th incident, Ethan Crumbley acted in such a way that would lead a reasonable observer to know and or believe that he was planning to cause great bodily harm to the students and or staff at Oxford High School. By the way of example and not limitation, previous to the November 30th incident, Ethan Crumbley posted countdowns and threats of bodily harm, including death, on his social media accounts, warning of violent tendencies and murderous ideology prior to actually coming to school with the handgun and ammunition to perpetrate the slaughter. For example, a threat on social media included an update to his Twitter account the night before, which read, quote, "Now I am become death, the destroyer of worlds. See you tomorrow, Oxford," end quote. On or about November 16th, 2021, days prior to the actual incident, multiple concerned parents provided communications to defendant Wolf with concerns about threats made on social media. This is going to fire y'all up about the school. If you're not already fired up about the school, this is only page 8 of 46. And when you find out everything that the school knew and didn't do anything and allowed this kid to go back to the bathroom with his backpack, he already had his backpack in class, and that's against the rules there. He wasn't supposed to even have it in the room when he was caught Googling and drawing those pictures. On or about November 16th. Okay, so yeah, defendant Wolf got some messages from parents. I know it's been investigated, but my kid doesn't feel safe at school, and he didn't even want to go back to school today, were a couple of the things that were told to the principal. On November 16th, that same day, Wolf emailed the parents indicating, I know I'm being redundant here, but there is absolutely no threat at the high school. Large assumptions were made from a few social media posts, and the assumptions evolved into exaggerated rumors. Mistake number 1. Don't underestimate social media posts. Defendants Throne and Wolf reviewed the social media posts of Crumbley prior to November 30th, which threatened Oxford High School students.
What?
Defendants Throne and Wolf had actual knowledge of concern from parents of students at Oxford High School, as well as the students at Oxford High School. Despite the posts and knowledge of threats of violence, defendant Throne sent correspondence and emails to parents at Oxford High School, reassuring them that their children were in fact safe. Following November 16th email exchanges and other communications, defendant Wolf to the parents of Oxford High School students, Superintendent Throne warned the students via loudspeaker to stop spreading information over social media and stop relying on information on social media, reiterating that there were no threats that posed any danger to students at Oxford High School. At times relevant here too, defendant Throne, while acting as superintendent of Oxford Community Schools, discouraged students and parents from reporting, sharing, and otherwise discussing the threatening social media posts. At all times relevant here too, Ethan Crumbley's Instagram and other social media accounts were not set to private and were available to the public, including defendants. Defendants Throne, Wolf, and other employees and or agents of Oxford Community School District had knowledge of threats made to the students, including the plaintiffs in this case. At all times relevant here too, plaintiff minors were safer before defendant Throne took action and advised each and every student, including the plaintiff's minors, that there was no credible threat. By virtue of defendant Throne's actions, he substantially increased the harm to plaintiff's minors. Defendant Throne knew and or should have known that his announcement to the students at Oxford High School would discourage the students and their parents from reporting credible threats of bodily harm to teachers, counselors, and staff of Oxford High School. I thought schools, let's take a little break here. I thought that schools had a zero tolerance policy on drugs and weapons. Doesn't that include any kind of threatening drawings, things like that? Wouldn't his Instagram post have warranted zero tolerance policy? I'm just curious. This school's in hot water. They're getting their asses sued. It's not good. I didn't know if we did away with zero tolerance because my kids haven't been in school in years now, but yeah, I thought it was zero tolerance whatsoever. So I don't know.
I don't know.
He doesn't know. He does not know.
Okay. At all times relevant, plaintiff minors were safer before Wolf took the actions described and advised every student that there was no credible threat. Defendant Wolf should have known that his assurances that social media threats were not credible would discourage the students and their parents from reporting those threats. Okay, here we go. On November 26th, Ethan Crumbley's father, James, purchased a Sig Sauer 9mm semi-automatic handgun for his son. On November 26th, Ethan Crumbley posted a picture of the gun to his social media with the captions, "Just got my new beauty today," with an emoji and heart eyes. Followed by Sig Sauer 9mm. Any questions, I will answer. At all times relevant here too, Ethan Crumbley posted to his Instagram account a post with the picture and caption of the gun. This post was for public viewing and accessible to all defendants. On November 27th, 3 days before the incident, Jennifer Crumbley posted a message on her social media account reading, "Mom and Sunday, testing out his new Christmas present." At all times relevant here too, Jennifer Crumbley's social media was not set to private and was available to the public. Jennifer Crumbley's social media account with the picture and caption of the gun was available for public viewing and accessible to all defendants prior to Ethan Crumbley returning to school on Monday, November 29th. On November 29th, defendant teacher number 1 observed Ethan searching for ammo on his cell during class. Teacher number 1 did the right thing and reported the incident to counselor number 1. Kenny knackers, then you get the school resource officer involved. And then they search it. These people are responsible for hundreds of children's lives every day. Yeah, I know a kid in school that got expelled for that too, for wearing a shirt that he wasn't supposed to wear. I remember back in the 90s, we couldn't wear that shirt to school that said, "These colors don't run." Remember that during the Iraqi war? "These colors don't run." We couldn't wear that to school. But this kid can do this shit and they don't do anything? No. Wrong. We are in a totally different age and day. When we couldn't wear "These colors don't run," the worst thing we had to worry about was a damn fake bomb threat. Shame on these school officials. Shame on them. My niece went to school here. It pisses me off. So teacher number 1 did the right thing, reported it to counselor 1. However, teacher number 1 allowed Ethan to stay in the classroom despite the threats of violence with the minor children at Oxford. Teacher number 1 knowingly and deliberately decided to exclude the school safety liaison officer from notice of such dangers, despite knowing that Ethan was searching for ammunition during class. And the aforesaid social media posts regarding his weapon were available to the public, including teacher number 1. Defendant teacher 1 had actual knowledge of the violent threats of bodily harm and had further knowledge of Crumbley's intent to perpetrate those acts when she found Ethan Crumbley searching for ammunition and then did knowingly and deliberately decide to exclude the school safety liaison officer from reporting this incident. Now, if you're a teacher and you see a kid in Oxford searching ammo, I'm going to say it's a little bit of like a country area. So there's a lot of like deer hunters and shit in that area. Now, I don't know what the teacher saw on the phone exactly, but in all fairness, there are a lot of people who hunt in that area. And being that it was November 30th, that would be deer hunting season in Michigan. I don't know if that plays any factor. I'm just giving, what I know because I grew up right there. Okay, so on November 29th, after meeting with Counselor 1 and staff member, as a result of Ethan Crumbley's search for ammunition, Jennifer was contacted via phone by staff member who left a voicemail regarding Ethan's inappropriate internet search. So the day before, they called Jennifer and emailed Jennifer. Counselor 1 and staff member made a knowing and deliberate decision to exclude involving the school safety liaison officer of Ethan's behavior, and knowingly decided to refrain from informing the school safety liaison of the meeting with Ethan Crumbley regarding the same. Defendants teacher 1 and counselor 1 deliberately and knowingly sent Ethan Crumbley home after school without any discipline or follow-up search regarding his inappropriate search for ammunition. At all times relevant, defendant staff member knew and or should have known that the information regarding Ethan's inappropriate internet search would likely be relayed to Ethan Crumbley by his parents and would encourage and or entice Ethan Crumbley into more affirmative actions. At all times relevant, the students at Oxford High, including the plaintiffs, were safer before staff member affirmatively contacted Ethan's parents and apparently chose to allow Ethan to return to school the next day. This action assisted with an acceleration of plans to effectuate his slaughter of classmates. Defendant staff member made a knowing and deliberate decision to not take any meaningful corrective action against Ethan Crumbley, increasing the risk that plaintiff's minors would be exposed to Ethan's acts of violence. So the teacher sent him down, said, hey, he was searching ammunition. They said, Ethan, what are you doing? They emailed his mom, called his mom. She didn't answer, and they said, fuck it. He went home with no follow-up. At all times relevant, plaintiffs were safer before blah, blah, blah. On November 29th, when defendants teacher 1 and counselor 1 knowingly and deliberately released Ethan without further investigation or discipline, further, Ethan Crumbley's public social media posts regarding his gun and Jennifer Crumbley's social media posts were available to the dean of students, school principal, superintendent, counselors, and teachers, including defendants, all of which altered said defendants to the imminent attack. Upon information and belief, in the evening of November 29th, after defendants, teacher 1, counselor 1, and staff member released Ethan from school without discipline and without investigating his inappropriate internet search and without notifying the school safety liaison officer, that Ethan Crumbley posted to his Twitter account. Now I am become death, the destroyer of worlds. See you tomorrow, Oxford. Although his Twitter account was set to private, the posting he made was to his public profile biography, invisible to anyone who could search his name, including the defendants. Ethan Crumbley returned to school the next day unchained. The students were safer before the defendants knowingly and deliberately allowed the murderous student to return to school the next day, despite the clear and present dangers at Oxford High School. At all times relevant, defendant teacher 1, counselor 1, and staff member made a knowing, intentional, and deliberate decision to intentionally withhold and exclude important and vital information from the school liaison officer before allowing Ethan Crumbley to return to school the next day, putting all students in immediate danger and accelerating Crumbley's plans to slaughter his classmates, thereby increasing the risk that plaintiff's minors would be exposed to Ethan Crumbley's acts of violence. On the morning of November 30th, defendant teacher number 2 discovered a note on Ethan's desk, which alarmed her. In which she reported to defendant Moore and defendant counselor 1 and took a picture of said note with her cell phone. Now, I agree with you, Madison. I think the teachers did what the teachers were supposed to do. But nonetheless, obviously in a civil suit, they're all going to be named. So I don't think the teachers hold the responsibility like the higher ups. Okay. Upon information and belief, the note contained the following: a drawing of a semi-automatic handgun with the words, "The thoughts won't stop. Help me." Thank you, Painting Services by Steve.
Roberta.
You grew up in Milford. Oh, wow. In another section of the note was the drawing of a bullet with the following words above the bullet: blood everywhere. Between the drawing of a gun and a bullet is a drawing of a person who appears to have been shot twice and bleeding. Below that figure is a drawing of a laughing emoji. Further down are the words, "My life is useless," with the words, "The world is dead," to the right. All these people read this. Trained counselors read this. But when the parents are non-compliant, what do you do? What do you do? Jennifer Crumbley didn't return the call on the 29th. Jennifer Crumbley didn't return the email on the 29th. She was too busy out hoeing around with her boyfriend or whatever the hell she was doing.
My last name's Dirk.
The voices won't stop. Help me. Voices and help. School resource officer was needed. Defendant teacher number 2 was aware of the school policy excluding backpacks in the classroom, and teacher 2 made a knowing and deliberate decision to leave unsearched Ethan Crumbley's backpack even after discovering the alarming note. They allowed Crumbley to continue to maintain control of his backpack, phone, and other possessions, giving him easy access to store a gun, therefore increasing the risk that the plaintiff minors would be exposed to Ethan Crumbley's acts of violence. At all times relevant, the students of Oxford High were safer before defendant teacher 2 took action and intentionally did not report the violent note drawn by Ethan Crumbley containing threats of bodily harm, including death, to the school liaison officer, causing Ethan Crumbley to have the opportunity to shoot the classmates, but to do so on an accelerated timeline, thereby increasing the risk that plaintiff's minors would be exposed to Ethan Crumbley's acts of violence. Upon information and belief, upon discovery of the concerning note, Ethan Crumbley was removed from the classroom in front of his classmates with his backpack and was made to sit, by defendant Counselor 1, and was made to sit in the office with Counselor 1 and Counselor 2 for approximately an hour and a half while waiting for his parents to arrive at the school. Defendant Counselor 1 knew or should have known that by removing Ethan from his class in front of his classmates with his backpack and making him sit for an hour and a half while waiting for his parents, after Ethan Crumbley had drawn violent pictures and notes depicting death and violence against students at Oxford High School, such actions would further accelerate Ethan Crumbley's murderous plans. This is a civil suit, Chick Valley, and this was filed by Jeffrey Feiger and Associates against Oxford Community Schools. Hi, Heather J. Upon information and belief, during the period of time that Ethan Crumbley sat with the counselors, he maintained control of his backpack, which then contained the gun with 30 live bullets. Hey, LNG, what up? Defendant Counselor 1 and 2 knowingly and deliberately decided to exclude the school safety liaison, despite having knowledge of threats against the school, Ethan Crumbley's search history the day before, and the violent drawing, which were the reason for his removal from the classroom. They had an hour and a half. They were sitting there with him for an hour and a half. They could have contacted the school resource officer in that hour and a half and had him meet with the parents as well. At all times relevant, the students of Oxford were safer before they took action. And upon information and belief, Ethan Crumbley's parents arrived at the school and a meeting was held with Counselor 1, Defendant Counselor 2, Defendant Moore, Defendant Staff Member, and Defendant Wolf. All these people were in the meeting. With Ethan, and at which time they were shown the drawing and advised by defendants that Ethan was required to go to counseling within 48 hours. If you think that a school can't search your backpack, but can order you to go to counseling within 48 hours or they're going to call CPS, you're mistaken. They can look in your backpack. All they need is a reason, and they had more than one reason to check his shit. Upon information and belief, Ethan Crumbley's parents were advised by the defendants that a failure to attend counseling within 48 hours would result in the school contacting Child Protective Services. Counselor 1 and 2, Moore, staff member, and Wolf took these actions during school hours while the students were present at Oxford High School. After the meeting, the defendants and Ethan Crumbley and his parents, with them, Ethan returned to the classroom with his backpack containing the gun and 30 live bullets. He was sitting there, right, Scott Skulls. He was sitting there for an hour and a half with that damn gun and 30 live bullets. Kenny, you don't know that, though. I mean, how can you say, I'm sure they tried to search the bag, but he didn't allow them? We've never heard that. We've never heard that Ethan and his parents refused. They don't need his permission. They have to keep all the other students safe. Ethan Crumbley's rights don't matter in that case. At all times relevant, the defendants deliberately conducted this meeting, excluding the school safety liaison officer from the meeting, thereby preventing him from being present at the meeting. At all times relevant, plaintiffs were safer before they held that meeting. Okay, I'm just skipping over this redundant stuff. So they're just listing everything he's done. They've said that, because of their actions, it made the kids even more at risk. So number 87, defendants knew that threatening to call CPS within 48 hours and threatening without action to remove Ethan Crumbley from his home would create and or increase the likelihood that Ethan would carry out his plan and slaughter. He lost the opportunity given the prospect of threatened Child Protective Services intervention in the coming days. Upon information and belief, after being allowed to return to his classroom, Ethan Crumbley took his backpack to a school bathroom and sometime after returned to his class, loaded ammunition in the gun, and walked out of the bathroom to design the massacre. And no, backpacks are not allowed in the classroom. He wasn't supposed to have it in there, but they didn't do anything. Defendants gave Ethan Crumbley the opportunity to go to the bathroom with his backpack to prepare for his planned rampage, thereby increasing the risk that the plaintiff's minors would be exposed to his acts of violence. At approximately 12:52 p.m., authorities were notified of an active shooter at Oxford High School. Upon information and belief, Ethan Crumbley's massacre was halted when he was apprehended by law enforcement. On November 30th, 2021, Riley was shot in the neck as a direct result of each and every one of the within enumerated actions of defendants, causing her severe trauma, PTSD, fright, shock, terror, anxiety, as well as physical and emotional injuries. Bella narrowly escaped the bullets discharged towards her, her sister, and her friends. She observed her sister, friends, and classmates being shot and murdered, causing her severe trauma, fright, shock, terror, anxiety, post-traumatic stress disorder, and emotional injuries. I was late, Debbie. That's why it was so late, or so long. On December 1st, Ethan Crumbley was arraigned and charged as an adult with 1 count of terrorism causing death, 4 counts of first-degree murder, 7 counts of assault with intent to murder, and 12 counts of possession of a firearm in the commission of a felony. The risk that Ethan Crumbley posed a substantial and deadly harm to other students was obvious and known by the defendants. Number 107, defendants' conduct was outrageous and shocks the conscience. 108, defendants are not entitled to governmental and or qualified immunity. And then plaintiffs hereby reincorporates and reasserts each and every allegation in this complaint. Now, let's go down here to 113. So this is just stating all of their names and basically more legal stuff. But here we go. Their actions created the danger and increased the risk of harm that their students would be exposed to. Private acts of violence, to wit, deliberately and intentionally returning Ethan Crumbley to class with a loaded gun, deliberately deciding not to involve or advise the proper police authorities, choosing to return Ethan Crumbley to class with a gun after he had been actively searching for ammo the day before, deliberately choosing not to search Ethan's backpack, choosing not to report Ethan's internet search to the proper authorities, deliberately returning Ethan to his classroom with a loaded gun after confiscating a picture which demonstrated a high likelihood that Ethan Crumbley would effectuate a slaughter, choosing to intentionally handle the complaints and threat of a school shooter in the days leading to the November 30th incident, rather than involve the proper police authorities, deciding not to inspect the backpack, even though they maintained custody and control over the backpack and the locker. Concealing facts from the appropriate law enforcement authority before returning Ethan Crumbley to class. Choosing not to report his suspicious behavior to Child Protective Services. Choosing not to report his suspicious behavior to law enforcement. And interviewing Ethan Crumbley in front of his parents, knowing that interview would accelerate the violence planned. Choosing not to have an appropriate mental health intervention prior to him returning to class with the loaded gun. Demonstrated conduct so reckless that it demonstrates a substantial lack of concern for whether an injury would result, causing the plaintiff's minors extreme emotional distress. And all other breaches become known throughout this litigation. Okay. So then down here, it lists all of the damages that they are claiming for the two minors that were there. And they're suing in excess of $100 million. So here we go into the superintendent, defendant Throne. And they're talking about him encouraging the specific incident of misconduct and directly participating in it by not reporting or mentioning the threats against Oxford High School. Same goes for defendant Wolf, who is the principal. This is a civil suit in the Oxford High School shooting. They're saying by not expelling, disciplining, or, whatever. They didn't follow through, and it's just repeating it. Let's get to the better stuff here. Here we have the repeat. It's going to be repeated twice because there's two defendants, the kids, that are suing the school. No, there's more in here, you guys. I just have to get past the repetitive part. Oh, this isn't the one with the dang evidence attached. So they, hang on, where did it talk about the schools, like the counselors deleted their social media? Hold on. I think that's in this part. Wait, hold on. I have another document, you guys, because this really puts the school on blast. Motion to preserve and restore evidence. Come now. Now come plaintiffs, Jeffrey Franz. Through their attorneys, Feiger, Kenny, and Harrington, PC, and hereby move this court for an order to preserve and restore the certain evidence. This lawsuit arises out of the horrific and tragic shooting at Oxford High School on November 30th. Several events prior to November 30th, 2021, and the day of November 30th, 2021, perpetuated by defendant Oxford School District and their agents, created harm and danger to the minor plaintiffs. Further information on the allegations are contained in the plaintiff's complaint. Letters demanding that all evidence be preserved and requesting that all records relating to this case be produced to plaintiff's counsel were sent to the following entities: Verizon, T-Mobile, AT&T, Abbey Ridge Apartments, Meyer, Tim Hortons, Oakland County Dispatch, Office of the Michigan Attorney General, Oakland County Prosecutor, Michigan State Police, Oakland County Sheriff, Department of Justice, FBI, Oxford Community Schools, Instagram, Facebook, Snapchat, TikTok, YouTube, and LinkedIn. On the date of the filing of the complaint, December 9th, counsel for the plaintiffs noticed several social media pages of the defendants and web pages were deleted on behalf of Oxford School District.
What?
You heard that right. Several social media pages of the defendants and web pages were deleted on behalf of Oxford Community School District and named defendants. Electronically stored information is information created, manipulated, communicated, stored, and best utilized in digital form requiring the use of computer hardware and software. Social media accounts and web pages clearly fit in the category of electronically stored information. And then here is the federal law on preserving evidence. Then it says not only did defendants fail to take necessary steps to preserve the evidence, but they willfully destructed the evidence by deleting the web pages and social media accounts. By way of example, here we go. Here's more. Moore is put on blast by way of example. Defendant Ryan Moore's LinkedIn page was deleted on December 8th and in the early hours of December 9th, including in the hours following the complaint's filing. Defendant Moore's social media appeared as followed. So there it was. That's what it looked like. Defendant Moore's social media handle is clearly displayed on the webpage. In the evening of December 9th, Defendant Moore's social media page then appeared as follows. It is evident that defendant destroyed his social media page. Oxford High Administration listings had also been deleted. Error messages are found on the Oxford High School web links. This honorable court has the power and authority to control the discovery process and its cases and may exercise its authority to promote efficiency throughout litigation by requiring the preservation of evidence, which will facilitate timely, efficient discovery objectives. Since the date of the incident, plaintiff's counsel has had concerns of withholding and destruction of evidence from the defendants. Unfortunately, the actions of the defendants have solidified plaintiff's counsel's concern, requiring and necessitating court intervention. The destruction of evidence, withholding of evidence, refusal to produce evidence has and will continue to result in extreme prejudice to plaintiffs. Any electronically stored information can be rewritten or destroyed by the time plaintiffs are able to obtain the evidence. Plaintiffs have rights under federal law to obtain complete and accurate information and evidence involving this matter. Given the high-profile nature of the events on November 30th, defendants had noticed that litigation was likely and had reason to believe that litigation was anticipated, thereby triggering the need and requirement under the court rules to preserve evidence. Preservation and subsequent production of such evidence is likely to narrow down the issues in this matter and assist in expediting the litigation process. Plaintiffs request that the honorable court enter an order halting any further destruction of evidence, ordering that web pages and social media pages be restored, or in the alternative, holding a show cause hearing to discuss sanctioning the defendants for participating in obstructionist behavior just hours before the commencement of a lawsuit. Defendants are aware that litigation requires them to not only preserve evidence, but to specifically not destroy evidence and also turn evidence over to plaintiff's counsel. I find that strange too, Cheryl. Plaintiffs respectfully request this honorable court grant this motion to preserve evidence. Signed, Nora, Hannah, Jeffrey Feiger, Kenny, and Harrington. So this repeats pretty much their first complaint. And they want all evidence preserved. So they went to the website and there were broken links on the school website. School officials were deleting their LinkedIn accounts and their social media. Not looking good for them. And I think that is the end of this one. And like I said, this was filed on December 9th and it's been stayed or whatever, the school has kind of delayed any action going forward. So it hasn't had any movement. But yeah, Nora is the legal assistant to Jeffrey Feiger. I'd love to be Jeffrey Feiger's assistant. All right, so what do you guys think? I mean, what do you think about, I know I saw you guys saying, they should have done all these things, check the backpack, da, da, da. I think there was several steps that, could have been handled in a totally opposite way. But what started this ball rolling? I mean, what was the first mistake? I feel like the teachers reported what they saw in their classroom. And that's pretty much all you can do as a teacher, right? Now, I don't know if it was up to the teacher to involve the school resource officer or the counselor, but none of them did. And it's interesting because I can't believe out of all these officials, the superintendent, the principal, several counselors, staff members, 2 teachers, the dean of students, none of them mentioned the school resource officer. I mean, they had to have discussed it. I mean, these posts, these pictures you're seeing on the screen were available on his social media for all of these teachers and officials to see. Parents, you got to parent your kids. You can't just give them what they want and let them go on their way. Look at this worksheet. Help me. He tried to scribble it out. They could clearly see that he wrote, help me. Oh, Oxford school superintendent calls claim in lawsuit over shooting irresponsible and false. I had no idea they were looking. Look at Oxford. Oh, that's Oxford Hills. 2 weeks ago. Oh, here we go. Oxford school students must show IDs to enter the school. And this was put out Sunday, January 30th. So just this past Sunday, according to Superintendent Tim Throne, starting Monday, students will need to show their ID to enter the building. According to the superintendent, this stems from a student entering the building Thursday. You can listen to the entire message from Superintendent Tim Throne here. Let's do that, shall we? Let's see what Timmy Throne's got to say.
Good afternoon, Wildcat Nation. I want to thank you for taking the opportunity to listen to this short video and read the attached document. I want to let you know that we had just a great first week back. I was up there the first part of the week, and it was just heartwarming to have our students and staff and administrators back in the building. I also want you to know I was out of the district on Thursday and Friday. Although I was out of the district,
Hold on. Madison Vocal. School officials are not going to see a student's social media unless they are deliberately looking for it. That is not a common thing to do and can be considered illegal. It's not illegal to look at someone's public social media when they see a student exhibiting violent behavior. Definitely not out of the ordinary to look at their social media. Kids live on social media. Are you kidding?
We had just a great first week back. I was up there the first part of the week, and it was just heartwarming to have our students and staff and administrators back in the building. I also want you to know I was out of the district on Thursday and Friday. Although I was out of the district, my cabinet, our administrators, everybody was working diligently here to figure out what had happened. They've been working ever since then, trying to
I can't with
come
the
up
music.
with our game plan going forward. I was actually in Lansing on Thursday. As we continue to just grieve the events of November 30th, I wanted to provide them an update on where we were. I wanted to give them an update on our just tremendous return this past week. I also, quite honestly, solicit their support in the days and weeks and months to come. Please take the time to go through the attached document with your son or daughter. We don't want them to be anxious. We don't want them to be surprised for how they're greeted on Monday.
What?
Obviously, you know that we had an issue of a student entering the building on Thursday, and that's really what the heart of this message really pertains. My cabinet members, our administrators, have been working around the clock determining what happened, what type of temporary actions we can take moving forward to make sure that this doesn't happen again. You will see some of those details in the attached document of exactly what did happen, as well as what our plans are for this coming week. I would ask that you read through the attached document, go over it with your son or daughter, let them know that we are asking them to bring their student IDs with them on Monday. We don't want them to be anxious. We don't want them to be surprised for how they're greeted on Monday.
Is he going to keep repeating
it's
himself?
Take more time to actually have the students enter our building on Monday.
Welcome, Miss Robin.
But at this point, again, we think this is necessary. And so while it is temporary at this point, we don't know how long it's going to go on. We may find other things that we want to tweak our processes and our procedures with how students enter the building. But this is our best plan forward at this point. We're listening to you, we're taking action, and
this is the superintendent of Oxford Schools.
We want you to make sure that not only you know that, but that our students know that as well. Our students were incredibly brave this week, returning to school, along with our staff members and our administrators. I am just so proud of them. We are looking forward to Monday, to another first, the start of the second semester. And so thank you for your continued trust in us. Again, please read through the attached document. Let your son or daughter know what is going to be expected of them when they arrive on Monday. And we can't wait to see them. It's a great day to be a Wildcat.
Are you serious right now? IDs? That's all they're gonna do? Is IDs? Thank you, Lauren. Thank you for your donation.
Roberta.
Wow, I didn't watch that whole thing. I was saving it for this live. I wonder if he'd feel the same way about a parent reading the attached document. If his kids went there. Here's 11 days ago.
Hello, Wildcat Nation. As we approach the opening of Oxford High School, I wanted to take this opportunity to extend a huge thank you to our entire community, especially our students, our families, and our staff. And we've had construction crews working tirelessly to renovate our building, and we've had our staff working really hard to prepare our students for a safe return to school. Now, we have been through so much to get to this moment. We've been grieving together, we've been praying together, we've attended funerals, vigils, and memorials, and we have been absolutely heartbroken. And we've been angry, yet we've been determined to carry on. And I am so proud to say that we are reopening our high school this Monday, January 24th, and we are reclaiming our high school back. Now, we have been so blessed to get to this point, and we've had so much help from outside groups, countless experts, law enforcement, mental health experts, and especially our families, our staff, and our students. And your feedback has been invaluable in the return to school planning. And we would not be at this point without the support of our entire community, our Oxford community, and even our surrounding communities. So from the bottom of my heart, thank you. We can't thank you enough, and we could not have done this without you. And we know it's going to be really difficult for our students and our staff to come back because we're still grieving. And our thoughts and our prayers will continue to be with the victims of this senseless act and this tragedy, and for those who continue to heal. But throughout the last several weeks, we've been reminded again and again of one important fact. Our community is strong. And when we stick together, we are incredibly strong. And that has never been more true than in the last 2 months. Please know that when our students return to school, we will have numerous mental health resources available to them. And students, remember, being Oxford strong means asking for help when you need it, because we're all going to need some help getting through this. And the physical and emotional safety of our students remains our top priority. This has been our guide for planning our return to school and will continue to be our North Star as we continue to make decisions and move on in our planning. And we've heard loud and clear from our families that you do not want media on our property. And so we've asked the media not to be on school grounds until further notice. And we want to continue working our way towards as close to normalcy as we can to finish out the remainder of the first semester as we begin our second semester. And we truly look forward to welcoming our students back to school on Monday. And they'll be warmly welcomed by our staff, who've been missing them so much while they've been away. And now students, you have been filling us up with a tremendous amount of love and a tremendous amount of hope. And we can't wait to continue pouring that right back into you. As Martin Luther King Jr. said, darkness cannot drive out darkness. Only light can do that. Hate cannot drive out hate. Only love can do that.
This wasn't a
And
hate
students,
crime.
we love you. We cannot
my
wait to see you on
God.
Monday. And it's going to be a great day to be a Wildcat. And that's because we're Oxford strong.
Ew. What? What is with these videos? Why can't they just be real? Guys, I'm from this area. This is a small town. I've never seen anything like this. I would think they would be so much more personable. I know Oxford schools have grown. I saw that Potato said there's 1,300 kids in the school, but my goodness. I would not feel safe sending my kids back either. Very strange. And that's it. So they're showing IDs. What's that going to do? It wasn't a kid that didn't go to the school. Oh, shit. Here's another article. Something happened yesterday. Let's see what this is. They've never had a shooting at Oxford. Ever. Okay, so here we go. This is yesterday. The superintendent of Oxford School said reports of a fight at Oxford on Monday involved an altercation between two students. There was an altercation between two females in a math classroom. The two girls in the classroom actually got into an altercation over a desk. The superintendent was unable to provide any additional information on the occurrence, which sparked rumors on social media about students being arrested. In response to claims of police presence on the school campus, Robertson said the students were not placed in an OPD squad car and that school resource officers on campus were assisting other issues on the campus, such as traffic. And that's it. That's it. Oxford, what the hell is going on? So this is the other lawsuit that was filed. This is a 107-page lawsuit. This is the one that made the news. The other one didn't make the news. But there's Tim Throne. I think there's a video on this. Oh, yeah, this is weird. Okay, look at this. Okay. The amended lawsuit. Okay, so Feiger amended the lawsuit that we read. The amended lawsuit filed late Friday continues to list allegations against one man whose school district lawyer, Timothy Mullins, said has not worked at the district in more than a year. Mullins has called the allegations false. What are the odds? Feiger has added some negligence counts to his complaint, and now, as before, he doesn't even know who he's suing, said Tim Mullins on Saturday. Yes, Laura. The school's lawyer's name is Timothy Mullins. Mullins previously said Oxford school officials will claim that they are immune from liability. There is a criminal investigation and prosecution taking place, and the Oakland County prosecutor has asked us not to comment upon the facts of the case as to avoid any interference. Mullins said, our priority is to get the kids back to school. There will be plenty of time for comment. The lawsuit accuses school officials of failing to stop an attack that inflicted physical and psychological injuries on students and spreads the blame high shell among highest-ranking Oxford school officials, along with unidentified teachers and counselors. The attack was the country's deadliest school shooting since 2018. Killed in the attack were Oxford High School students Hannah St. Juliana, 14, Madison Baldwin, 17, Tate Meyer, 16, and Justin Schilling, 17. The lawsuit includes details that have emerged in several court filings and appearances since the shooting. Crumbley allegedly told counselors once he was taken to the office that his drawing was part of a video game he was designing and that he planned to pursue video game design as a career, said Tim Throne. Crumbley remained in the office for about 90 minutes and worked on school assignments while the school tried to reach his asshole parents. What made you laugh, happy girl? His parents were informed they had 48 hours to seek counseling for their child, or the school would contact CPS. They were asked to take their son home for the day, but they flatly refused and left without their son. Police have said they believe the handgun was concealed in his backpack. Feiger accused high school principal Stephen Wolf of knowing about the threats of violence from Crumbley, according to the lawsuit. The principal made the situation worse, said Feiger. Defendant Wolf excited Ethan Crumbley by pulling him out of class, warning him that CPS might be called without actually calling CPS, thereby encouraging Crumbley to accelerate his timetable for murder. I know, I can't get away from Tim Mullins, right? The lawsuit faults two unnamed school counselors for failing to report they found violent pictures and notes and that he threatened violence against other students. And that is the update. The Illuminati triangle. I noticed that on, I know you're talking about this right here. The Oxford. I know. That's why I looked at the channel. I'm like, what channel is this on? And I'm like, oh, it's Oxford. Yeah, I don't know. Info Communications. It's very weird looking. I mean, I know this school, but it's just very weird.
In labor relations.
Yeah, a bunch of junk. So they're hiring a new principal. And yeah, a lot of their videos are unlisted. Like that one that we watched, the only one that's public is the principal. The one from the other day is on unlisted. Interesting. Freddie, this concludes our Oxford Community Schools. Thank you so much for joining. Thank you. Thank you all the mods for showing up. You guys are the best on the tubes.
We planted flowers on the side of the house.
Thank you so much, guys. See you soon. Peace out.
I don't give a damn. I don't really care about you and your problems. I don't give a damn. You talk way too much. I have heard enough about you and your problems. I don't give a